accounts by providing the following information: the social media account provider, his username for the account, and the email he used for the account. But basically, our position is that information shared on a social media platform can be relevant to the decedent's mental and physical condition leading up to the accident. And they can be relevant to his relationships with the plaintiffs, who are all wrongful death beneficiaries. And they're relevant specifically to the plaintiff's claims of loss of companionship, mental anguish, those types of things. And the interrogatory is reasonably calculated to lead to the discovery of admissible evidence.
And Your Honor, we think that we see this in a lot of cases. This is just a fishing expedition, and it really is. I've had to produce some of this in a case before. And what happened was they got a ton of information that was completely invasive to the rights of third parties, that had nothing to do with the case at all. And in a case like this, where there's been a death, there certainly couldn't be any relevance to what there might be in a social media account. And then, I mean, the next problem with that would be that because there is somebody who's dead here, they're asking for the decedent's social media accounts, and the representative of the state doesn't have the requisite knowledge that only the decedent would have had in order to identify each and every social media account. In addition to that, I think it's overbroad because it's talking about any and all social media accounts in the first part of the request. But I just don't see how really social media could be relevant in this case when our plaintiff or the decedent was driving down the road and the defendant pulled out in front of him, ran a stop sign.
Okay, so the decedent in this case is the defendant, I guess?
No, the decedent in this case is William Cody Childers. He is the deceased husband of Haley Childers, who is the first of the named plaintiffs.
Yeah, and what happened, Your Honor, is he was driving a motorcycle down a road, and he was coming up to, it wasn't a full intersection, but there was a road that was running, I guess, completely perpendicular to the road. And the defendant driver was driving down this road right here, and he had a stop sign. The plaintiff did not have a stop sign, and he was driving through that. It's not an intersection per se, but he was driving through that road, and the defendant pulled out right in front of him, right at the last second, because I guess he didn't see him, and he ran right into him and he died. So just a fail to yield the right of way sort of case. It's not like a real difficult case. And so our position is that in a case like this, social media is not relevant.
I'm trying to think through this. So what would be relevant? I mean, like his history? I'm trying to figure out what in a situation I could see if he had continuing injuries, and you might want to know what did he post about his continuing injuries, but things from before the accident, there isn't a condition, he doesn't have, there's not going to be an issue as the pre-existing condition because he died, right? And so
he did die. The claimants, the plaintiffs, they're wrongful death beneficiaries, and they've alleged or they're seeking to recover pecuniary loss of companionship, mental anguish. And a factor that's going to go into the evaluation of those types of damages is their relationship with the decedent. And social media will give us some insight into what those relationships were like.
And Your Honor, this is what I'm talking about with the fishing expedition. It's what's posted on social media doesn't really tell you what a relationship's like. I don't even know if there is any stuff that's going to be between the decedent and any beneficiaries. But like I said, it's a fishing expedition that doesn't really have any sort of tailored relevance to the facts of the case.
So this might be a good
so there's two issues here: discoverability, admissibility. I agree with you that there'll probably be quite a bit that is not going to be admissible or relevant, but I'm going to allow it just to see what's out there. We could do like an in-camera inspection, but that would take way too long, and so I'll go ahead and grant it. But they only have to produce what's in their care, custody, and control.
And so this is for the rods. where it is identify
No,
the,
this is just the, yeah, the raw, it's number 16. All right, next we have defendant Leonard Walker's first set of interrogatories to Haley Childers individually as Amanda to Amanda Childers and to Charles Childers, 2, 3, 4, and 6. Are those agreed to?
Those we're working out. Yes, we don't need you to hear those.
Okay, what's next?
We do not need you to hear so the next one is Leonard Walker's first request for production to Charles Childers and to Amanda Childers.
Okay,
So on those, we do want you to hear the social media ones. That's numbers 28, 29, 30, 31, 32, 33, 34, and 35. So each, and if you'd like, I can share my screen with you and show you those as
Sure.
well. Okay, so so 28 is the first one. Each one of these asks for any posts or photographs shared on Facebook, Instagram, Twitter, Snapchat, TikTok, or whatever social media or online account from the date of accident to present concerning this lawsuit. The next one is limited to date of accident to present concerning any references or complaints about and the economic damages alleged to have been a result of the accident.
okay, so 28 is granted, 29,
well,
I'm
Your
not sure
Honor,
what that means.
Your Honor, our problem with that is why would that ever be relevant if it was after the incident? How could it be?
For what number, 29?
28.
28 is granted. So 29. I just don't understand what complaints about economic damages means.
Yeah, I think there was a typo in that. I think it's supposed to be references to or complaints about the damages alleged, including economic damages. The intent was to limit this request to posts and photographs shared about that would refer to the injuries or damages.
I don't understand this 29. I'm going to deny 29.
Okay. 30 is the next one. Posts and photos shared on any social media or online account from the date of accident to present concerning references to any elements of damages in the last live pleadings in this case.
I'm going to deny that one. What's next?
31 is the next one. Excuse me. Posts and photographs shared from the date of accident to present concerning plaintiff's recovery from any medical treatment they've received as a result of the accident at issue.
So if they've had were they involved in the accident too, or were they?
No.
They weren't involved in the accident too. Medical expenses have been alleged. My understanding from speaking with the plaintiff's attorney recently is that nobody's actually sought medical treatment yet.
In the police report, Your Honor, it's clear he was announced dead at the scene. There was no medical treatment. He died before the doctors got a chance.
Are you talking about the plaintiffs as in the beneficiaries? Are you talking about the plaintiffs, the decedent?
On this one, plaintiffs as in the beneficiaries.
Okay, and I was talking about the plaintiff as the decedent. And to date, there hasn't been any medical treatment. So I'm just not really sure what this is even asking.
Yeah, I'm going to deny this one. 32.
32. Posts and photos shared from the date of
32 is granted. 33.
33.
Granted. 34. Denied. 35. Granted.
And Your Honor, these are like, and so they're not limited to any specific person's social media account. So does this make us have to go find?
No, that's their own social media accounts. To the extent that's unclear, it's only their own social media accounts.
Okay.
So if they posted, and this would be weird, but if they posted a picture of the scene of the accident or the vehicles involved on social media, they would need to produce that.
Okay.
All right, what else do we have?
The next four are 40, 41, 42, and 43. Get there. So you, in this case, would be.
Who's Emily Drilling?
She is the decedent's girlfriend, or was the decedent's girlfriend at the time of the accident.
This is way too broad. That's the 9.
Okay.
41. Who's Brady McDaniel?
My understanding is he was Haley Childers' boyfriend at the time of the accident.
40 through 43 are kind of the same.
They're very similar.
Yeah, these are all way too broad. Deny.
Okay. And then the last two we'd like your ruling on are 46 and 47.
What is that?
And so you
Go ahead.
SETI. Well, go ahead, SETI.
I was going to say, I believe it's my understanding that this lawsuit was a custody issue about a minor child, a Haley and Williams minor child, was filed in 2019 before the accident that is subject to suit.
And what does that have to do with this case? That was that the minor child that died?
No, the minor child is alive, and she is one of the wrongful death beneficiaries that's claiming damages in this case.
And Your Honor, I think you're right on. It doesn't have anything to do with anything in this case. We think it's just another fishing expedition. We don't have the document. Thank you, Your Honor.
And what is this other lawsuit?
We believe that it's a divorce proceeding initiated by Haley Childers prior to the accident, in which Mr. William Childers died.
Wait. Who died again? William Childers?
William Childers.
Okay, that is granted.
And
Haley, just so I understand it, Haley was the wife of the decedent?
yes, and Your Honor, they never got divorced. They reconciled.
Well, this would go to the issue of what the relationship is potentially, so that is granted. All right, what else do we have? Is that it?
That's it.
So, Your Honor, just so we're clear, they don't have any of the documents in the pleadings. As like you can imagine, like, I know the lawyers, we all have our clients' documents and pleadings, but like, our clients don't always have them. So they don't have them. Is your order gonna require us to go to the court and get the public documents?
Anything under their care, custody, or control. So if they have an attorney that has all of this and the attorney will turn it over like a family law attorney, they would need to get that from them. They don't have to go to the court and get it.
Okay.
All right, I signed the order. Let's see, does it say, how about, this is a little extensive. I'll say within 30 days. All right, anything else, guys?
That's it. Thank you, Judge.
Thank you. You have a great day.
Thank you, Judge.
All right, our next hearing is Molina versus JWS Enterprises. Is everyone here for that?
Good morning, Your Honor. Christian Havens for plaintiff. I'm not sure anyone else is going to be here with us.
It's just to create a post-judgment receivership. Okay. And there's already a judgment in place.
Correct, Your Honor.
Let me just look at this real quick. Okay, and you've produced the order, or you've provided an order. Yeah.
2 separate orders for each defendant.
Oh, wait, say that again.
2 separate orders for each defendant. There are 2 defendants with judgments against them. And
oh, I already signed the one as the William Gomez.
The post-judgment receivership?
Yeah,
Okay, it had not.
it was signed on October 27th. And let's see, maybe I didn't do both of them. Are there two of them?
Yes, there's the William Gomez individual and JWS Enterprises, which is the LLC.
I don't think I've done that one. Let me see. And this was both, yeah, I haven't done that one. I don't think. Okay. All right, I'll go ahead and sign the other one.
Okay, great. Thank you, Your Honor.
All right, and usually just you don't need a hearing on these usually. So if this comes up again and there's not both orders signed, just call my coordinator and she'll submit it to me.
Okay, thank you very much, Your Honor.
All right, have a great rest of your day.
You as well.
So Tony, Rhonda, our next hearing's not until 3:45.
Okay.
All righty.
All right, we'll see you